Companies Act, Section 87, Rectification by Central Government in Register of Charges. Section 87 of the Companies Act grants the central government the authority to rectify errors, omissions, or delays in filings related to the Register of Charges. This provision ensures that companies are not unduly penalized for inadvertent mistakes, provided that such errors do not adversely impact the interests of creditors or shareholders. Below is a detailed breakdown of the section. Authority of the central government to rectify errors. The central government is empowered to make corrections in the Register of Charges if it determines that the errors, omissions, or delays were accidental, unintentional, or arose due to justifiable reasons. The specific circumstances under which rectification may be allowed are outlined below. Subsection A. Omission to notify the registrar of payment or satisfaction of a charge. Nature of the omission. This applies to situations where a company fails to notify the registrar about the payment or satisfaction of a registered charge within the legally prescribed time frame. Scope of rectification. If the failure to notify is determined to be accidental, inadvertent, or due to a valid cause, the central government has the discretion to rectify the omission. Objective. This provision ensures that genuine mistakes or unforeseen delays do not lead to undue penalties, provided that the omission is not deliberate and does not prejudice stakeholders. Subsection B. Omission or misstatement in particulars filed with the registrar. Types of errors covered. Omission or misstatement in filings related to the creation, modification, or satisfaction of a charge. Errors in documentation concerning memoranda of satisfaction or other entries required under Sections 82 and 83 of the Companies Act. Criteria for rectification. The central government must be satisfied that the omission or misstatement resulted from accident, inadvertence, some other justifiable cause, or circumstances that do not prejudice the position of the company's creditors or shareholders. Scope of intervention. If the above conditions are met, the central government may direct that the necessary corrections be made in the Register of Charges. Application for rectification. Who can apply? The company itself. Any person with an interest in the charge, including creditors, shareholders, or other stakeholders. Terms and conditions for rectification. The central government has the discretion to impose any terms and conditions it deems just and expedient. These conditions ensure that the rectification process remains fair and does not result in undue advantage to any party involved. Key considerations for the central government. Nature of the omission or error. The government must assess whether the error, omission, or delay was unintentional or resulted from a valid cause. Impact on stakeholders. Rectification will only be permitted if the correction does not negatively affect the rights or interests of creditors or shareholders. Fairness and expediency. The decision to rectify must strike a balance between ensuring compliance with the law and addressing genuine mistakes fairly. Objectives of Section 87. Remedial mechanism. This provision offers companies and stakeholders an opportunity to correct unintentional errors without facing unnecessary penalties, thus promoting fairness in regulatory compliance. Stakeholder protection. By ensuring that rectifications do not prejudice creditors or shareholders, the provision upholds the rights and interests of the company's stakeholders. Flexibility and equity. Section 87 provides the central government with the discretion to consider unique cases where strict enforcement of procedural timelines may lead to unfair consequences. This section serves as an essential safeguard within the Companies Act, ensuring that minor administrative errors do not lead to disproportionate penalties, while still maintaining regulatory integrity and protecting stakeholder interests. For more details, contact us.